I wanted to start out by reminding you kind of the takeaway from the last case we covered, the Burnham case. Essentially, they were just challenging the lawyer, meaning there's the idea that if you're in a state's presence, you're in a state's boundaries or territory, you're served with process, but that's enough to establish personal jurisdiction over that person. So essentially, Burnham was just challenging what I like to call tag jurisdiction, or Penoyer, and the court said basically Penoyer still did law. So that's essentially what was going on there. And so one thing that we highlighted in the takeaway is the two different perspectives of Justice Scalia and Justice Brennan in that particular case. So I want to remind you of their two positions because I'm going to throw you a hypo just to see how you think each of them would respond based on their stance. So the first one is Scalia. So in the Burnham case, as you might recall, Scalia believes that historically the Constitution enshrines the then prevailing views in the 14th Amendment that basically says while you're in the state, there's a separate basis for jurisdiction, meaning tag jurisdiction, where you don't need minimum contact. So again, Justice Scalia believes that historically the Constitution preserves the prevailing views that while you are in a state's boundaries, a separate basis for jurisdiction without requiring minimum contacts exists. Okay. Then you have Justice Brennan, who on the other hand agrees that service of process while you're in the state exists as a separate basis for jurisdiction, but also thinks you can't ignore the minimum contacts test. So he's saying, I agree, yes, tag jurisdiction, meaning Brennan still exists, but you can't ignore minimum contacts. Brennan engages in that analysis and basically concludes that, as you might recall, yes, it would be fair to exercise jurisdiction over Burnham, given the fact that they purposely availed themselves to the benefits of the state. So between those two, Brennan is saying, yes, I'm acknowledging tag jurisdiction exists, but I think you still have to consider some aspect of minimum contact. Specifically, he's referencing the purposeful availment component. Scalia is saying, no, Penoyer is enough. You don't need any contact whatsoever. It doesn't matter. It doesn't have to be part of the analysis. So with that pattern I wanted to present to you all is you have a defendant that's a citizen of the state of Georgia. She plans on vacationing in California and decides to drive from Atlanta to San Diego. On the way, she drives through Texas. She stays one night in a hotel in Texas on her road trip, so she pit stops on her road trip. The plaintiff serves the defendant who processed in Dallas for a suit in Texas concerning a claim that arose from one of her trips to Hawaii. So basically, she's on a road trip in the state of Texas. She stops overnight and gets served with process. She's like, whoa, like, that's not fair. So what would Brennan say? What would Brennan say? Yes, in the back, thank you.
She's in minimum contacts with the state of Texas, so therefore she can't be served.
Okay, who can make another argument? Elizabeth.
I would say Brennan would say she could be served because she has the minimum contacts just by staying in the hotel and staying there one night. So that meets his definition for that purpose.
Yes, and so Brennan would most likely say there is jurisdiction in Texas. By visiting one night, the transient defendant purposely avails herself, right? She's there voluntarily, of the benefits provided by the state of Texas. While she's there overnight, if she needs 911 services, she can call it. She's using the roads and highways, right? And think about it, Burnham was just there, just to pick up his kids and leave. I mean, she actually spent a night there, right? He would also say that while the individual was in Texas, their health and safety, as I mentioned, was guaranteed by the state's police, fire, emergency services, free to travel on the state's roads and highways, and basically just enjoy the fruits, or I'd say the fruits of that particular area. Like here in Kentucky, you can go to 4th Street Live or to the Florence Fort. Who's been to Florence Fort? It's really cool. Yeah, so basically we have a lot of biking and hiking trails here. So that would be Brennan's standpoint. Of course, Scalia would say, you know what, I don't really care if he has minimum contacts. I don't even need to have that discussion. Tag jurisdiction clearly applies here, so there's no need to even evaluate whether or not there's personal jurisdiction. It's enough that they were in the city or the state willingly overnight. Let's look at another fact pattern. Same facts, but instead of driving, right, the defendant flies from Atlanta to San Diego. And during their layover in Dallas, they get served with process. Again, concerning that same claim that arose in Hawaii. What do you think now Scalia would say? I know that you're ready now. Yes?
Yeah, she purposely availed herself to the state of Texas because she was laid over there. It wasn't her plans, and it's to in contact with Texas.
Okay. So I'm going to say yes for the part B. Your answer is right on point. Assuming that she wasn't there voluntarily, you're absolutely correct. You just messed up my next typo, so high five. But what I care about is you applied the law correctly. That's what I care about. So yes, so if you know that you're flying from Atlanta to San Diego, you know you have a layover in Dallas and you're served with process, you are voluntarily in Dallas, right? You know it's part of your trip's itinerary, and there's personal jurisdiction is all as well. And so, but if you were flying from Atlanta to San Diego, it was supposed to be a non-stop flight, and because of weather, you have to detour to Dallas and then continue your trip. You're not there voluntarily, right? And so you can make a stronger argument under Brennan that there are no minimum contacts. You didn't voluntarily purposely avail yourself to the benefits of that particular state. So you see the distinction on voluntarily there, as opposed to I end up getting my flight itinerary gets sidelined and I'm not there voluntarily. And that just goes to the whole notion of fairness. Whenever, regardless of what the context is, the judges are always looking, even if it looks like there's minimum contacts and all those things, they'll overturn personal jurisdiction just on fairness alone. They'll say, these are not unique, these are not, fair circumstances, and the due process clause will not allow us to proceed in asserting personal jurisdiction in this scenario. Because you got to think about, a lot of people might get tricked, and you just never know, invited to some bogus timeshare in North Dakota that guarantees you a week in Paris, and it's not legit. So you'd be surprised what people do for wealthy defendants that they're trying to serve process on. So I just want to really emphasize the importance of the fairness component, and the judges really consider that. All right. Great job. So good start. So let's go ahead and talk about the concept of consent in personal jurisdiction. So consent. So I know I said there were 5 ways to satisfy personal jurisdiction, which were the quasi in rem jurisdiction, tag jurisdiction, specific jurisdiction, and general jurisdiction. And again, when I say personal jurisdiction or in personam jurisdiction, they're all the same. So those are 5 ways to establish in personam jurisdiction or personal jurisdiction. They mean the same thing. But there's also a 6th way, which is consent. Which makes sense. You can consent to jurisdiction, right? That's kind of an obvious answer. So that's essentially what we're covering now. So the Supreme Court of Penoyer indicated that consent to a state's authority could provide a basis for rendering a judgment that's binding in terms of a personal jurisdiction ruling. Consent to jurisdiction can either be expressly implied or implied based on certain actions or waivers. We'll talk about those ways, but again, expressly applied, I consent, Your Honor, I'm fine. Defending myself in Indiana, I live across the river in Kentucky, no big deal. Or there are ways that you can impliedly consent. We'll talk about those in just a minute. And so international shoe characterize implied consent cases in terms of minimum contacts, meaning if you have minimum contacts with the state, we can imply from that you consented to a litigation that might occur as a result of your activities with that state. So that's an example of implied consent. If you're doing business in that state, we're assuming that you expect if there's a lawsuit that you're going to defend yourself. But consent to jurisdiction can also be found in other ways. One that's, I don't think it's in your current textbook, but it's the non-resident motorist statutes. Okay, every state in the United States has a non-motorist resident statute. And basically what it says, it provides that a non-resident motorist who enters a state and uses the state's highways and roads is deemed to have impliedly consented to the state's jurisdiction. So again, non-resident motor statutes provide that a non-resident motorist who enters the state and uses the state's highways and roads is deemed to have impliedly consented to the state's jurisdiction. All right, so there's a famous Supreme Court case. You don't have to know the case for bar exam or my exam purposes. It's just a kind of fun fact. It's Hess versus Pulowski, right? It's a 1927 U.S. Supreme Court case. And basically, that's a case that validated or established the constitutionality of these non-resident motorist statutes. It was a statute involving in Massachusetts. And so if a state has a non-resident motorist statute, which they all do, if you drive in those highways and roads and you get in a car accident, you have essentially consented to personal jurisdiction, meaning that state in which the accident happened would have personal jurisdiction over you. If you're thinking back to the Volkswagen case, we just give you abbreviated versions of that case to show a certain aspect of personal jurisdiction, but you could have looked for whether or not there was a motor statute in that particular case and trying to assert jurisdiction. That's not it. Okay, maybe not. So another way that I mentioned a little bit earlier that you can consent to jurisdiction is we kind of mentioned briefly the default judgments. So you can waive your consent by failing to object. So if a defendant fails to object to a court's personal jurisdiction within the time frames that are set out by Rule 12, which we'll discuss later, it's deemed that they have impliedly consented. So essentially, Rule 12 is a series of objections that you can make. I object, Your Honor, to the case being filed in Kentucky because Kentucky doesn't have personal jurisdiction over me. Your Honor, I object to the case being filed in Kentucky, being filed here because there's no subject matter jurisdiction. This case should be in federal court, not state court. It involves a constitutional question. So Rule 12 is objections that attorneys make in the courthouse to try to get a case dismissed. And so you have a certain time frame that's specified within the rule, and again, we'll spend 2 weeks on Rule 12. But you have a time frame that says you have X number of days once you receive notice of a suit to reject. So if you don't respond, then you impliedly have consented to have that state assert jurisdiction over you. Does anybody have any questions about that aspect? Okay. And so another thing that's interesting too is that if a non-resident plaintiff files a proceeding, say in Kentucky, and then the defendant responds with a counterclaim, well, if you respond with a counterclaim, then this court's assuming, well, you responded with your counterclaim, so I'm assuming that you don't mind trying the case here. So that's another way you can consent, trying to represent yourself pro bono. Not pro bono. Pro se, thank you. And you don't know that little aspect, you can screw yourself over. So it's better to not respond if you challenge jurisdiction. You can always assert counterclaims later. That's another way you can impliedly consent, which makes sense. And so most of the entities will appoint an in-state agent. So like if you're doing business, a lot of states require, if you're going to do business in the state of Kentucky, I'm trying to think about, what about the scooter company, right? Was Laura still talking about that?
Yes.
Oh, I love it. All right, you know she's going to bring it down. You guys are not going to have the scooters anymore. She's going to figure out a way to bring it down. So contact the provost. But say if you're that scooter company and you want to do business here in Kentucky at UK, U of L, and the other colleges and universities, the state of Kentucky will require you to have an in-state agent on file with that registered corporation or company or business that says, in the event of a lawsuit is filed, this is where you can start process. You don't have to run around trying to figure out where the CEO is or where their upper level corporate or business leaders, or it's a way of saying if you're going to do business here, we're going to appoint an in-state agent. And so again, a condition to doing business within the state, again, is typically required of business associations, corporations, partnerships, and so on. And then there's something I want to highlight on page 159. They talk about forum selection clauses. It's the bottom of 159, but definitely the bottom. Yes, the bottom. So they talk about forum selection clauses, and they basically limit the forum of where you can bring a suit to a single location. So a lot of contracts will have a forum selection clause and say, if you're going to do business with me in Kentucky, scooter company, then if there's any legal disputes, they have to be litigated here in Kentucky, and they put that clause in the contract. So by signing that contract, you're consenting to that selection clause, that forum selection clause. We're going to have the case litigated here in the Eastern District of Kentucky. And a lot of businesses do that. It makes sense. And if you have a client that you're drafting a contract for, you always want to include that to protect your client from being hailed in court somewhere that's inconvenient. So that's just part of contract law, and it's pretty standard at this point. So in terms of the contractual forum selection clause that I was just referencing, the forum selection clause basically seeks to provide a court with personal jurisdiction and to establish venue. So it's 2 things. It establishes the state in which the litigation will be brought, as well as what court within that state. That's venue that we haven't covered yet. So is it going to be in the Eastern District of Kentucky or the Western District of Kentucky? So again, these forum selection clauses provide a court with consent for personal jurisdiction and venue between the parties that have entered into this contract. We'll talk about these forum selection clauses, obviously, through the Carnival Cruise case, which I think is interesting. So as a general rule, most state and federal courts will uphold these forum selection clauses that are in contracts unless they can prove, and I don't know if have you discussed in your contracts class yet ways to invalidate a contract through like duress and unconscionability? Yeah, so those are ways that you can invalidate a forum selection clause. And I kind of wonder, I'm curious what your thoughts are when we talk about the Carnival Cruise case, or whether or not you feel that forum selection clause should have been invalidated for one of those reasons. So keep in mind that although litigants can consent to a court's assertion of personal jurisdictions, you cannot contractually consent to subject matter jurisdiction. So that's a very important distinction. So let me back up a little bit. So remember, to file a case in civil court, you need proper notice, personal jurisdiction, subject matter jurisdiction, and proper venue, right? And so you can contractually agree to consent to personal jurisdiction in a particular state, meaning that state has jurisdiction to hear your case. You cannot contractually agree that if we have a dispute, we're going to have this case in state court, or we're going to have it in federal court. So remember, I told you, we'll talk about when we discuss subject matter jurisdiction in more detail, that you are strategic about whether or not you file a case in state court versus federal court. Because again, the federal judges have lifetime appointments, state court judges don't. So if you're a local business and this judge is run on the idea of Louisville's local first, then you want to do state court, right? In hopes that you're going to have a more favorable outcome. So it matters. But you cannot agree to subject matter jurisdiction with one of these forum selection clauses. Okay. So let's go ahead and talk about the Carnival case. We have Attorney Fields, where art thou? Okay. Hi. I didn't know your last name. And then Attorney Belanki, I think we're back. All right, you should be a partner today. We're ready. Either of you give me the facts. Doesn't matter.
Okay. So the Shoots purchased they reside in Washington, and they purchased cruise tickets through a travel agent who's also in Washington, and they paid the fare to the travel agent, which in turn paid the fare to Carnival, which is headquartered in Miami.
Okay.
And on the ticket, there was like a clause basically saying that if there should be a suit for any injuries or anything, it would have to be in the state of Florida.
All right, excellent job. All right, okay. just highlighting some of the stuff she said. She was very succinct, so I don't have to say that much. But these were, in Carnival, we've got two Washington, right? State of Washington residents. Yay. Mr. and Mrs. Shute, and they buy this this cruise ticket through this travel agency. Pretty normal set of facts. We've all, not all of us, but many of us have used a travel agent at some point in time, unless you're frugal like me. All right, so we know that all the contacts are through the travel agency when they get their tickets. They include a forum selection clause, ouch, stating that, as she said, Florida would be the state to address any form of litigation. All right, so they fly to California to take the cruise, and off Mexico, what happens, Attorney Malaki?
Uwala Street was injured when he slipped on a cat mat near the guide floor.
Excellent, and so they filed suit where?
They filed suit against Carnival Cruise Lines and U.S. District Court for Western District of Washington.
Excellent, why do you think they picked Washington?
Because federal courts have subject matter jurisdiction over admiralty matters.
Excellent, yes, yes, yes. What's another reason Mrs. Fields is not in the books? Like, what is a...
Because they live there?
Yeah, their home state, right? So they would have picked, as Attorney Belanki said, federal court because it's dealing with admiralty law. Impressive that he remembered that. Most people don't. And then probably at home, this makes sense. It's not as expensive. It's not as inconvenient. It might be difficult to find an attorney all the way in Florida and you're living in Washington. So it makes sense for them to say, hey, we're going to file it in Washington. So how is this case different from the contractual provisions that were in Burger King? Does anybody remember? It was a couple of cases ago, so if you don't, it's okay. But the difference between the contractual provision in Burger King, I'm going to remind you because it was a couple of cases ago, and I don't expect you to memorize the whole book. Yeah, do you remember?
Was it because the provision in Burger King was that it would be Florida law, not
Yes.
in Florida?
Yes. Do you remember what that's called? You don't need to because you just shh. That's it. Knock down the ballpark.
It's not arbitrary law?
Yes. Wow. Okay, sorry. Yes. Remember I said they have a whole law school class on choice of law that you can take. So law, it gets really kind of murky. So, like, you learn this different content areas here in law school, which is great. You learn through this class in criminal procedure how do you file a case in civil court or federal, civil or criminal court. And then what they do is once you figure out, okay, I can file this case in that particular court, then you have to figure out which state's law to apply, and that's choice of law. So it goes on a whole other level. So it might be in federal court, but you're applying state law because it's, because of a series of rules, but it's like a huge, complicated web. And you want to argue some states' law might be more favorable than others. Like if I have they're trying to give me for marijuana, right? I want Colorado law if I can, I don't want to go to jail. So it matters though. So choice of law. So Burger King was a choice of law. They said that they would use Florida law would apply in the event of a lawsuit. So what was the holding by the Supreme Court? Not the reasoning, but just the holding, either Attorney Fields or Attorney Blunt. What was the holding? Did they conclude that the parties were bound by the foreign selection clause or not? Attorney Blunt, go ahead. Thank you.
They said they did conclude that they were bound.
Okay. And so why did the court say that?
They said they gave 3 reasons.
Okay.
They said a cruise line has a special interest in limiting the flora in which it could potentially be subject to suit, and having forum clause indispels confusion where suits might arise, and also passengers who purchase tickets containing a forum clause benefit in the form of reduced fares.
Absolutely, yes, 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 and more yes. Okay, so essentially the court's rationale, they said, and then I'll highlight those 3 points that he made because they're essentially what we care about, that by paying for and accepting the ticket, right, that included this provision. The Shutes had actually, the court said, consented or waived their right to sue Carnival in Washington and agreed that all litigation would take place in Florida. The court's rationale were the 3 things that Attorney Belanki pointed out. Number 1, avoiding litigation in multiple sites. You don't want Carnival crews having to litigate. I mean, think about, obviously the passengers are from all around the country, so it's, again, that's one rationale, avoid litigating in multiple sites. Second, no confusion amongst the parties about where to sue or defend. And then lastly, he said cost savings, right? Pretty obvious. Essentially what they said, there was reciprocity. The court, they said, look, the plaintiffs, meaning the Shutes, benefit from lower ticket prices, right? Because the defendant isn't forced to have to litigate all around the country when stuff like slips and falls happen. So they're getting a benefit as well. They're getting a lower plane ticket. So who thinks that's crap? Who's seeing those tickets? Like when it's written on the back, it's like there's no way my parents would know to look on the back of a cruise ticket, right? For a freaking forum selection clause. Yeah.
Well, it does say that the travel agent made him aware of it.
Even still, do they know what it is? And how many travel agencies have ever made you aware? Who's used your parents or someone's used? I've never heard of a travel agency telling you about a foreign selection clause when you're buying tickets. I don't think it's the norm. Yes.
Well, they didn't even go to Florida. They got their boat in California. So they were never present in the state of Florida at any point. So, like, I don't understand
how they can make that, because they consented to jurisdiction. Do that clause and buy that ticket, yes.
Also, the idea that they're going to pass on the cost to the consumer is pretty laughable.
Oh, what, like the baggage claim cost?
Yeah, right.
Baggage
We're saving
cost?
money, so we're going to pass it on to y'all.
Yeah, thanks. Distributed well, right? Paying for it. Is anyone how just a show of hands, who says that this is not fair? These foreign selection clauses. Yeah, there was actually, it was a couple years ago, there was a congressperson, I don't remember his name, but he was trying to pass a law that says that foreign selection clauses would not be allowed in contractual travel agreements, just because he felt like it was unfair that most people don't know to look on the back of that little ticket. It's always in such small writing, and he just thought it was such a disservice to regular people like you and I to have to fly, across the country when I'm the one that slipped and fell because they were negligent and left the deck wet, knowing that there were passengers, walking in that area. And it felt like he felt like it was prohibitive to them pursuing a lawsuit. I know I have a lot of family members who would say, yes, I failed, but I don't have the money to pay to go to Florida or try to find an attorney there, to litigate this case for me, so just forget about it. My leg is healing anyway. And that's not a good thing. So it definitely can serve as a deterrence. And so the court says in part that because foreign selection clauses provide certain benefits, they should be upheld under certain circumstances. They describe those circumstances on page 157 of your text. The 4th paragraph, they say, quote, foreign selection clauses are subject to judicial scrutiny for fundamental fairness. We're back to the fairness. So focus should be on notice to the plaintiff in bad faith on the part of the defendant, and then fairness. So again, they do still focus on, is this foreign selection clause fundamentally fair? I think there's a strong argument that it's not. I just don't think, I think it's so screwed that you take a cruise or a flight and there's an issue. And, there's no way I would expect to have to go to another state unless I'm a lawyer to defend myself. So I don't like that. So applying the standard to this case, the court elects to uphold this foreign selection clause because, why? Why did they elect Attorney Fields to uphold the foreign selection clause?
Basically, they were saying that there was no, fraud, I guess. So, they weren't trying to discourage passengers from bringing suit, just trying to pinpoint where the suit should be brought. So they said there was really no issue, which I disagree with. But
why do you disagree?
because I just pictured them as like a little old family trying to go on vacation, and then they get hurt, and then have to go all the way to Florida to defend themselves from this big company that could have easily just came to their state.
Do you remember what they said about the where Carnival did its principal, not business, but most of their cruises and stuff? Did they take that into consideration? Where the majority of their cruises, what port they leave from?
I don't remember.
Attorney Belanki. Oh, that's court said, look, there's no evidence of fraud obtaining to the chute's consent. Plus, they had notice allegedly through this travel agency. They said Carnival Cruise Line had a principal place of business in Florida, and the majority of its ships all departed from Florida, from Miami. And so they said basically there was just no indication that Carnival Cruise set Florida as a forum in which disputes would be resolved to discourage passengers from pursuing legitimate legal cases. Yes.
I remember when I was like applying to law school and everything. One of the other schools I was looking at was the University of Miami. And so
You came here, all that sunshine.
Yeah, right. Anyway, I was like checking out the legal market and everything there, and I started reading about this big issue that was going on with like the Carnival Cruises and all those like similar kind of companies where the litigation was so backed up for some of those like torts and negligence cases that the actual trial wouldn't be taking place
For years.
for a substantial amount of time versus another district that they could have easily gone to.
That's not it. Excellent. Thank you so much for sharing that. So that shows one of the unintended consequences of these forum selection clauses. So they have completely overwhelmed the dockets down there in Florida, and that's definitely to me enough. Remember, when fairness, which component of fairness, the 5 fairness factors, could he make the argument that the clause should be invalidated? Which one of those aspects of fairness? Yes.
Plaintiff's interest in obtaining effective and convenient relief.
Yes, and what about also, remember there's that weird kind of category about social policy and substantive policies? Like, I think it's good for social policy to have cases litigated in an expeditious manner, especially when we have torts where people have been, mauled, maimed, whatever. There was a case here, did you all remember in Kentucky Kingdom, they said that somebody's ankles were cut off on one of the rides? I don't want to have to wait, 6 years, 5 years to get my case litigated and get redressed. And I'm walking around with no ankles. So that's a true story, huh?
They took the ride down too.
Oh, so the ride doesn't exist anymore. Yeah, who would actually, be honest, who would have the courage to get on that ride if they said, you can get into Kentucky Kingdom for free, but you have to ride this ride first? Who would do it?
Not worth it.
Okay.
Wait, can I still sue?
Are we giving consent to whatever you're
No, but why would you care if you could sue? You don't have any feet.
I had law school
I think they're
Oh, you do?
I think so. I think they're going to maybe attach.
Every attachment. Well, that's good. That's
It
good.
depends if they work. Like, you can be attached
See,
to
that shows you what law school can do. It's really
it.
sad. It'll make you say, well, if I just lose like a hand, I can put it back on.
I'm just waiting for my moment.
Law school.
Ready.
All right. Yes, yay. Hold on so we can hear a question. Sorry, it's my fault for getting you guys
Would forum selection clauses make more sense for certain types of businesses, like if they're maybe a smaller business, where they really cannot afford to be subject to multiple jurisdictions?
That's not fair. So what about the bigger corporations who are keeping Walmart keeping the prices down, because they exploit their workers and they make it affordable living here in Louisville. So should we want, I don't know. We should, the warm and fuzzy part of us, yeah, just the big corporations can afford it, but then as they implied in this case, they're going to pass those expenses on to us consumers, so prices are going to go up.
Well, I'm still too poor to afford a cruise ticket either way, so.
But when you are in a position to afford it, it matters to you. The cruises are substantially higher. I think that's what ticks me off about the airline thing is the tickets are still the same. Gas is so dirt cheap now, and why am I still paying baggage fees? I just am so resentful. And if it's like that when I retire, I'm gonna make that my parting gift to the world. I'm gonna go after them. All right, so what else was there? Oh, Justice Marshall and Justice Stevens dissent on page 158 attempts to make a point of why Carnival itself would want the litigation to take place in Florida. So Justice Marshall and Justice Stevens say they hold that the forum selection clause really is unreasonable in their opinion in the dissent, especially since the chutes, and I love this, they had no choice. They had no leverage whatsoever. It was a forced waiver because it was included in the ticket. And so what the dissent is saying, which I think is a really good point, I'm not really consenting. Like, I'm not given the choice. I'm not, at least in a contract negotiation, like with Burger King, they negotiate, okay, yeah, we'll accept this forum selection clause. Choice of law clause in this contract. But there's no negotiation. If you think about the little bit you have learned in contracts, like where's the, what do they call it? Consideration. There's none. Acceptance, offer, what is it? Acceptance, consideration, offer, mutual. What are the steps for forming
Offer,
contracts?
acceptance.
Say it again.
I just know like a few of them. I'm trying to think about the
So you
flow
all
chart.
just
That
memorized
flow.
before the exam. I respect that. That was a lot of information, so it's okay. But when you do your bar prep, it'll all come back to you. But okay, so I think that's a really good point. When you're not given a choice, why are you saying I'm consenting? It's like, I don't know, I think the dissent's making a good point. So what's important to remember about this Carnival Cruise case is there's a whole body of law on the enforcement or non-enforcement of forum selection clauses. Obviously, we only skim the surface with this one case. It's also, the Carnival Cruise Line case is significant because it's really a test for the validity of a forum selection clause. So it's really kind of seeing, it put it under judicial scrutiny and said, okay, yes, these clauses are still valid. And these clauses are increasingly common, more and more common. Lots of companies use them. Like I said, they're kind of standard practice. And the truth is, the court's ruling in this case is a very pro-business perspective, right? I'm not really looking out for the little guy in this. I'm kind of like we saw with Daimler. Oh, they're not enough sales to be at home. It's only 2.4% of their billion-dollar business, right? So you'll start to see as you continue to go through law school. Some cases decisions are pro-consumer, some are pro-business. It just kind of depends on the mood and sway of the court. So that's it. So we're actually done with personal jurisdiction. There are no more cases. You can now actually outline, right? Because we've covered all the parts. So we're going down that little, those categories. So next we're going to talk about service of process, right? So that was another one of those components. Remember to file cases in court. If you can take a moment, if you have your laptop on you, if not, you will not be at a disadvantage, and pull up Google Rule 4. I did not have to buy a supplement because there's another $50 book that you can get online. So just Civil Procedure Rule 4. Does anyone have the supplement? Like the book, like another class, I'm just curious. Okay. So Rule 4. So when you have it up, so basically Rule 4, we're now going to start getting to the point where we actually have rules. We like this, right? So you know, like Professor, what's the rule in the case? You go to the rule book, which is going to be your online version. So our first rule is Rule 4. So Rule 4 governs service of process. So those are the rules of civil procedure that you have to follow to make sure you have properly served process or notice on a defendant that there's a lawsuit filed against them. The rule has several parts. It tells you that you can't, for instance, file notice against a minor. It tells you the different ways you can file notice and notify an individual that are constitutionally permissible. And so essentially, the notice entails a two-step process. So providing notice entails a two-step process. First, you must determine whether a rule or statute prescribes a method for giving notice, right? So is there a rule or statute that provides a method for giving service? Here's going to be yes, there's Rule 4, right? And some of the state, that's for the federal rules. In some state courts, they have statutes that tell you what you have to do in the state of Kentucky if you're filing in state court to serve process. We're focusing on the federal rules. So we're going to say, yes, there is a rule, it's Rule 4. So the first step is determining whether a rule or statute prescribes a method for giving notice. The second step is assessing whether the rule or statute meets the requirements of due process. So first, is there a rule or statute that tells us the requirements for providing service process? Second, if there is a rule or statute, does it meet the requirements of due process? So the Malayan case represents the second step, which is whether or not service of process addresses due process requirements, or fulfills due process requirements. So again, the Malayan case addresses that. All right, so what are the three ways to serve an individual defendant? If you look at Rule 4, E as in Edward, the number 2, so 4E2. For exam purposes, I would never say I need 4E2, section AB. I would just say which rule? Rule 4? Okay, thank you. But I'm just telling you where you can find it. So Rule 4E2 says the first basic method for providing service is personal service, so that's one way, personal service. The second one is substitute service, and then the third is service on an agent. And I'll tell you what each of those are. But again, the first type of service you can do is personal service, the second is substitute service, and the third is service on an agent. Service on an agent. All right, personal service. That's just an individual serves on a person individually, right? Or the officer does it, like a police officer. So basically, a process server just delivers the notice of a lawsuit directly to the person. So it's no secret Jedi definition, is what it sounds like. Personal service. Attorney feels you can serve a process. Have a good day, man. And so personal service can be made anywhere within the forum state, and that's just going back to Penoyer, essentially. So anywhere within the state where you're trying to bring the lawsuit. And that's the extent of personal service. The second one, substitute service. That is service at an individual's dwelling or usual place of abode, right? With someone of suitable age and discretion who resides there. Now that's the issue one. All right, so substituted service is at an individual's dwelling or usual place of abode. So either your home, or if you're at your partner's home, more than that can be considered a usual place of abode with someone of suitable age. And so different states have different age requirements. For instance, Florida says anyone age 15 or older, right? So a process server will say, you know, the young man answers at the door, how old are you? You know, I'm from blah, blah, blah. Oh, I'm 15. They can serve them, right? And the defendant is out of luck. Essentially, if that person doesn't give the paperwork to them, they've been served. So if they happen to serve notice at a time where your teenager's like, you know, you're in trouble. that's reality, okay? Service on an agent, authorized by the appointment or by law. So that's, I mentioned that every state says if you're going to do business here, you have to have an agent authorized by law or that's appointed, and a physical address where where service of process can occur. So again, service on an agent just means if you're doing business or you have a company in the state of Kentucky, and you want to serve process on them about a lawsuit or notice, you can look it up on Kentucky One Stop is what it's called, with their business site, and say, okay, here's a physical address, right? And go from there. So it's important to note that Rule 4E1 allows a federal court to incorporate state law methods of service, and that's important where, like I said, if you're Burger King and you're serving process of someone in the state of Florida, even though your case is in federal court, which is part of that choice of law class, would apply that state's requirement of the 15 years and older. Some states have 18 and older, so it just kind of 16, 15. They kind of range from 15 to 18. So that's important. Now, service of process on business entities is governed by Rule 4H, right? 4H in theory. At your leisure, I encourage you to read that. I'm not going to test you on it, but just so you know how to serve process on businesses. 4H is in theory. So now that we've discussed the mechanics, let's talk about the general federal rules for service of process, specifically the due process requirements and constitutional standards of notice. All right, so you might remember from the first week of class we reviewed the 5th and 14th due process clauses. We determined that the due process clause provides that the government may not deprive someone of life, liberty, or property without due process. The leading case which discusses the constitutional requirement for notice is this Malayan case. So we read this case because of those two problems that I told you have to do in determining if service of process was done in a way that your case won't get dismissed. Again, first, you just determine if there's a statute or rule for the jurisdiction you're trying to file a lawsuit, which is going to be Rule 4. If it's in federal court, state court, you're going to look at the state court service process statute. And then two, if the way that you plan on serving process will meet those constitutional due process requirements. Essentially fairness. Is your process likely to inform the person in a fair manner that there's a lawsuit filed against them? All right, we're ready for our last case. Yay, we are, because then you're off till next week. Sort of. Come on. I'm gonna bring food. Usually when I bring food, sugar, and caffeine, people are a little bit more. Plus I know it's early. Attorney Belanki, you are officially a partner. You knocked the last case out of the ballpark, so we might as well keep it rolling. Can I have the facts, please?
Yeah, in 1946, Central Hanover Bank Trust Company established a common trust fund according to the New York banking law.
Excellent. So, the case facts are not, it's kind of, I don't want to say they're confusing, but if you don't have a banking background, they're kind of dense. I can't really liven them up, but I can try to explain them in a little bit more layman terms. So here we go. All right, so in this case, there is a pooled or common trust, okay, trust fund going on here. So it's a collection of 113 smaller trusts. The bank, which in this case is Hanover Bank, right, is a trustee, and they're in charge of investing the money and then distributing it, right, to all the proceeds to the beneficiaries. So it's kind of like if you think those money marketing funds that people have, where you invest in a bunch of different entities and hopefully you're making a profit. So the bank basically petitioned the surrogate courts and for settlement. And a surrogate court just hears cases on trust, wills, and decedents, right? So the bank petitions the court for settlement of its first account as a common trustee. So each beneficiary of the trust needs to be notified of this judicial settlement of account. So essentially what the bank is doing is saying, look, we think we maxed out all the profit we can get for this account. We'd like permission from the court to settle this judicial account, and we'll distribute the proceeds. But we want, basically a certification from the court saying we have done our fiduciary duty, we've managed this account in a fair and equitable way. And so what is a judicial settlement of accounts? It's basically a judicial decree, right, that the bank did everything right in administering the trust. That's all it is. So a judicial decree that the bank did everything right in administering the trust. So the investments were proper, the fees were reasonable, etc. And it's basically just to prevent people from coming back later and challenging the distribution of the funds. So it's a liability shield. So why is it important for trustees to seek judicial settlements? Well, the accounting decree handed down by the court binds everyone that's participating in the trust, right? So trustees need to protect themselves, as I said, again, against potential liability, negligence, if they say there's a breach of their fiduciary duty and whatnot. So the issue in this case is whether the constitutional sufficiency of notice to the beneficiaries regarding this request for a judicial settlement was fair, right? So did they meet the constitutional requirements for fairness with respect to the notice they gave to the beneficiaries. Hey, we're trying to get a judicial settlement of this account. Is everybody with me? All right, cool. So we know the issues here is notice to the beneficiaries. Attorney Phil, who did the bank give notice to? How did they give notice to the beneficiaries? 2 ways.
One, they did by mail of the people that were of full age, sound mind, and of the addresses that they had, and then I think they also published something in the newspaper.
Yes, excellent. I'm just a curiosity question. So do you handwrite out your brief and then you have stuff on your computer as well?
I type them, but then I just like doodle on them, I guess.
All right.
And then I take notes on my computer. It's a mess.
Yeah, it's not a mess, but there's just multiple layers.
Yeah.
All right, so great. So we know that they tried to serve notice 2 ways. They're like, look, we mailed a notice to everyone's address and contact information we had, right? They say a full age and sound mind. And second, they published the notice not for 1 week, not for 2 weeks, but for 4 weeks in a local newspaper per the New York banking statutes. There's a statute in New York that says in the state of New York, like they were saying in the state of Kentucky, you can't do service by publication. So they were trying to fulfill that particular aspect. So the notice only had in the newspaper the name and address of the trust company, the name of the common fund, and a list of the 113 participating trusts, nothing else. Did not include the name of the beneficiaries. So I don't see my name. No one who happens to be reading the paper sees my name and says, yo, Laura, your name's in the paper about some kind of litigation stuff. So they did not include the name of the beneficiaries. So why were the beneficiaries served in this manner, Attorney Belanki?
And why the bank chose to publish it?
In the newspaper, yeah.
Probably because they wouldn't see it.
That's the truth. That's the true reason. But do you remember what they said in the case? Go ahead, Jessica.
They didn't. Some of the beneficiaries were not residents of New York, and they didn't have contact information for them.
Yeah, so they're kind of in a tough bind here. They're like, look, for the people that we don't have the addresses for, as Attorney Belanki said, they're like, good, let's just put it in the newspaper. The New York statute says we can do it, and hopefully they won't see it, right? That's probably the truth. So that's why they chose that second state. All right, so Mullane begins an examination by noting the court that due process clause applies to this, again, New York statute. We're like, even though it's a state statute, due process, don't forget, always applies. So due process doesn't apply to everything, but it does apply in this situation. So how does the New York procedure implicate any of these items? Why does due process apply to this particular case? And the reason is because it deprives the beneficiaries of property. Remember, you can't deprive a person of life, liberty, or property without due process. So the property they're being deprived of is money, right? Money. So trust money. So how are they losing property or money? Well, because they lose the right, to challenge fees, breach of fiduciary duties, mismanagement of funds. They're losing the right to challenge misuse of their funds, and a reason why perhaps they got less than they think they should have been entitled to. So just a reminder that property is not necessarily cash or land. It can include intangibles like this, right? So the judicial settlement procedure is binding, and again, deprives them of the right to contest the amount of property, i.e. trust funds they actually get. So it's not fair if this account is closed, and then I don't get notice of the judicial settlement, and then I get my little check in the mail, and I'm like, what the heck? There's no way I should only be getting a check for, $2,800. It should have been at least $10,000. What the heck happened? I do some research and figure out that one of the fiduciary directors gave himself a significant raise, right, of $200,000. And I can't challenge that because the judicial settlement decree has already been filed. So that's why it's super important. All right, and so we know here that the due process clause applies, and that there's proper notice for property deprivations such as those in Mullane. Does notice require that the defendant actually know about the suit? And the answer is no. So I'm going to say that again. Does service of process require that the defendant actually know about the suit? No, it's not actual notice. So the test is, the court instead holds that they look at whether it's constitutionally proper, meaning the notice is fair. So not whether or not it actually notified them if they received notice, but was the process fair, right? And so essentially what Mullane says, which is the takeaway from this case and the most important aspect, at the bottom of page 164, they say that notice must be reasonably calculated under all circumstances to notify the defendant of the action and afford them the opportunity to respond. Their formalism is not enough. So again, the notice must be reasonably calculated. That's how you determine. So if you're arguing before a judge and saying, hey, Your Honor, they're using Rule 12, they just filed a Rule 12 motion to dismiss the case for improper service of process. And Your Honor, I'm telling you that you're going to cite the Mullane case, they're still citing it, it's the most current case. You're going to cite Mullane and say, the methods we used were reasonably calculated to apprise Professor McNeil that she had a lawsuit against her. These are what we did, these steps. And then the judge is going to look at what steps you did and say, you know what, even though she didn't get the notice, and that's what I'm upset about, I don't care, I didn't get the notice. My niece was staying at the house, she thought it was a joke, and she just put it, she put it in her backpack and forgot about it. And the judge is going to say, I'm sorry, Professor McNeil, that you didn't get the notice, but the way that it was provided to you was reasonably calculated to apprise you of the lawsuit. They came to your main residence, your usual place of abode, they were in compliance with Kentucky state statute, the individual was 16 years and older. I'm sorry, but that's what you look at, it's reasonably calculated, okay? And so, that's the test. So, the Mullane basically applies this test to the facts. And what does the court decide about this test? Attorney Fields or Belanki, what does the court decide about the case? Was this process fair?
They said it wasn't.
Okay.
Basically, they said it was incompatible with the 14th Amendment, and it's basically depriving. They basically had means to figure out where all these people were and figure out how to notify them properly, and that it's not an excuse basically because they don't know where these people are.
Excellent. So they said, look, as to the beneficiaries where the addresses were known, they said notice was constitutionally inadequate. They said the bank had to at least mail them additional information with respect to the beneficiaries who didn't have the address. They said that was ridiculous. Essentially, they said the newspaper failed, they said, because many of the service by publication, service by publication, they said that was inadequate, and that failed because many of the beneficiaries did not live in that area, so what's the likelihood they're going to get a newspaper and see that? And keep in mind, when you do service by publication, although many of us don't get paper newspapers anymore, my dad still does, I can't believe they still print them, but they do. It's in the classified sections where all those little, so it's not something that's real obvious for you to see. So they said that that was insufficient newspaper service process. The mailing of regulations, the court said, failed as well. It did not advise them of the date of the settlements, so even the known beneficiaries, they're saying the notification they gave them in the actual document was insufficient. And then lastly, they said, there are easy alternatives, as Attorney Fields said. They said, mailing to the known beneficiaries adds a little burden. They could have made a little extra effort to find the correct addresses of those people that no longer live in the area, especially since the bank make sure they mailed in their statements. So they felt like the bank definitely had the means of finding those unknown addresses for beneficiaries, and essentially they were just being a little lazy. So what about the other part of Mullane? The same type of notice was used for everyone. So why was this valid for another group, meaning not for one group and not for the other? And so, what are your thoughts? I try not to answer it. what were counter arguments on why it wasn't a big deal as to how stuff was done? So here are some of them. So they said, look, the deprivation isn't that big. You're in that section, they're like, make the argument, deprivation isn't that big. It's not tons of money in each trust or small amounts, not a big deal. Yes.
Yeah, when you join a trust, individuals agree on something different.
Yeah, and they said, look, they knew going in, this is how this trust was going to be managed, so there wasn't any type of fraud in that sense. They also talked about the state's interest as well in litigating this in New York, and so the court, in this case, really spends a lot of time talking about, and thank you, talking about publication in the newspaper. So does the court say that notice via publication is basically unconstitutional? Yes.
No. Well, they said, like, in the case of missing persons or unknown, that in that case, notification would have been almost impossible anyway, so doing at least putting it in the newspaper was a reasonably calculated way of notification.
Excellent. So they haven't said that service by publication is unconstitutional, so that's good to remember, but they're just saying that in this particular case, it failed due process requirements because, again, under the circumstances, it was not reasonably calculated to reach those who could easily be reached by other means. And so, a recap, just reminding you, if you're trying to determine service process notice, we're going to talk about this some more, but first you determine, again, is there a rule or statute that governs how the service process should be completed, and then if there is, was the notice reasonably calculated, right, under the circumstances to notify the defendant of the action and afford them an opportunity to respond. So was the means that you used to notify them reasonably calculated? Messed up. Just call them out. Was it reasonably calculated to apprise them of a lawsuit against them? Forgot to pass out the attendance sheet, sorry. All right, so for now what we have learned is the different ways you can achieve personal jurisdiction. We learned that the service of process, meaning notifying a defendant that a lawsuit has been filed against them, Rule 4 governs for the federal rules. Rule 4 tells you how you can do that. And you're going to look that up. Attorneys they look it up all the time and say, oh, I'm serving notice on a corporation. How do I do that? So it's like your little handbook for practice. So we know Rule 4 governs, and we know that essentially you apply that rule or an applicable state statute, and then you just look at the fairness aspect, and that's just whether your process was reasonably calculated to notify the person I sued. Isn't it great understanding this? Yes. I think it is. All right, I need to take roll. I messed up. It's easier than to pass around and just call your name. So Alan.
Here.
Bacchus.
Here.
Baker.
Present.
Vanda.
Here.
Baxter. Here. Bearden.
Here.
Blake.
Here.
Blue.
Here.
Boyd.
Here.
Burnett.
Here.
Cannon.
Here.
Church.
Here.
Clements.
Here.
Cole.
Here.
Doniger.
Here.
Douglas. Here. Emerson.
Not here.
All right, Fields. That was kind of weird. I'm like, just don't go. Okay, there's like a hologram sitting there freaking out. Fields, yes. Franz. Love that name. Griffith. Gross.
Which one?
Wait, what was that name?
G-R-O-S-S. Okay, Hall. Harper. Here. Healy. Hoffman. Horn. Here. Who's not here? Who's sitting by you is not here? Just that one? Do you know their names?
Oh, Church Finger.
There's no answer on me. So I have to keep going.
No,
Sorry.
really doesn't. No, I know, but you didn't get it.
So I don't know. Back to zero. Anyone else have names? Okay, got her.
Church Finger.
Him is like with an H?
That's just nice.
It's not on my thing for some reason.
Oh,
All right, cool.
but wait, I don't know if you have some names, but I think there's some of
Yeah,
you.
it's like between Cannon and Church. But,
Yeah, it's okay. Yeah, but as long as I don't mark you absent. That's the only people I have absent are Adam and Olivia. Okay, cool. We sort it out early. So what we're gonna do next week is it's actually gonna be a lot more fun. We're gonna look at service of process, but remember I told you I've got all these cool videos like of Justin Bieber, like you're gonna see it. And then we will continue on with venue. So we're like really doing well. Have a great week.
Yeah, I have